So you can see sort of the end, right? And the end, of course, is still continuing. We're sort of like into the abyss with this arrow. But in June 2022, after talking about it for a while and holding a lot of listening sessions, President Biden's Department of Education issued proposed rules. So that was the unofficial release. They did it on the anniversary of Title IX. It wasn't officially published until July 12th. Why does that matter? It's because that kicks off the commenting period. There were over 240,000 comments. So that's a lot of comments. Those were all submitted by last September 2022. And what happened was after that, we were all waiting for, okay, now how long will it be till final rules? Is it going to be the same time frame as last time? Is it going to be something, something longer? That's a lot of comments. That's more comments than last time. What are we going to see? And it took a long time. And then in May of 2023, the Biden administration issued a statement on a blog post of the Department of Education's website to say that even though they had planned for a May release of the final rules, it actually wasn't going to be until October. So now here we are. It is September 28th, and I think we're pretty much all in agreement that there's no way we're getting final rules next month. They haven't been through the administrative review process with the Office of Management and Budget, which is like a very long, boring story that anyone can. We have a couple articles about it on our website if you want to read more about those particulars. But even on top of that, with the impending government shutdown, none of the folks working on these regulations are considered essential, and the Department of Education is not a self-funding agency. So we just have all sorts of reasons why absolutely there will not be regulations in October of 2023. So I have a friend who likes to joke, well, they said October. Did they say 2023 or did they just say October? Maybe they meant 2024, 2025, who knows? But of course, that'll take us through an election season and we'll see what happens. This isn't the only thing that happened in Title IX in the past year. There were also proposed regulations on Title IX in athletics. In, I think, April of 2023, there were over 100,000 comments on those too. And the department indicated that it wanted to issue final rules on both together. So that also could be slowing this down. But all that to say, that's where we've been and a little bit of where we're going. But let's go back to, even though it says 2020, it's current, right? This is current. These are the current regulations. We're still living with them, even though we have proposed rules that are much more expansive and look much more like the vibe from 2011 through 16. This is where we still live, right? And the enforcement is interesting, but this is where we still live. The 2020 final rule was very narrowly only about sexual harassment. Those rules did not make any adjustments to the other parts of Title IX. It was just about sexual harassment, and it said that sexual harassment under Title IX only occurs in the program or activity, whether that is on campus or off campus, but related to the program or activity in some way. So it's, part of a program, part of a school sponsored event or trip or something like that. It only applies to a narrow set of violations. So those rules only impacted sexual harassment as defined in the rules, which includes quid pro quo harassment, severe, pervasive, and objectively offensive sexual harassment, sexual assault, domestic violence, dating violence, and stalking. So that doesn't mean that discrimination based on pregnancy or discrimination in pay based on sex is no longer covered by Title IX. It still is. It just wasn't impacted by these amendments from 2020. These amendments in 2020 only relate to sexual harassment. So hopefully that makes sense. Please forgive me if you can feel free to ask a question like, why are you talking so fast? That's a fine question. And I will answer it by saying, because I live in New Jersey, but I will also slow down. But I know we have a lot to cover and I want to make sure we get to it. But just feel free to send a flag my way if that is impacting your experience in this webinar. So what else? So there's a narrow concentration. There's a very narrow reporting process for Title IX complaints. Under the Obama era guidance, you could, say a Title IX concern out loud, and that would trigger an obligation by the institution. Under the current regulations that we're living in, you have to sign a formal complaint as a complainant or bring enough information to a Title IX coordinator that they will then sign a formal complaint. That has to be a written document under the current rules. So once you have a written document, of course, my question is going to be, which we'll talk about later, is What are you doing with it? Where is it going? Who sees it? How long are you keeping it? All of those questions. There's just much more significant process required. I'd say that the biggest change from if you came to me and you said, I've worked my whole life in residential real estate, what do I need to know about the Title IX changes from 2020? I would say the biggest change for a lot of private schools was that they used to not have a live hearing to adjudicate these concerns, and then suddenly they were required to, especially for colleges and universities. And the K-12 setting, it wasn't required to have a live hearing. But for a lot of private institutions, including many of my clients, 2020 was the first academic year. 21 was the first time they ever held a live hearing to adjudicate complaints of sexual harassment. And that's because it was required by law. So that was a really big change for folks. The 2020 proposed rules are really different, right? It's going to go, like I said, back to more that Obama era style, where much more, a heightened obligation for if a school has notice, a lower threshold for when there is notice, higher obligation to respond. The response it doesn't have to simply be not deliberately indifferent, but it needs to remedy the effects of the harassment, end it, prevent it if possible. If not preventing it, then responding promptly when it occurs, limiting the effects, remedying, and preventing recurrence, right? So all of those things. So you can't just, our response was, pretty reasonable. That's not going to be enough under the new regulations if and when they ever are final and implemented, which of course is not yet. But also another significant piece is the geography. So that the rules as they are now, if it's off campus and not in a school sponsored program or activity, there's no Title IX response. You are certainly permitted and maybe required under state law or your school code to proceed with some sort of investigation and adjudication under a code of conduct, but it can't be a Title IX complaint. In fact, it has to be mandatorily dismissed if it's styled as a Title IX complaint. And so the new rules, if and when they ever come into effect, the view there is that, hey, conduct that occurs off campus contributes to a hostile environment on campus. And this is the same view that we saw in the Dear Colleague letter from 2011. So it's just sort of coming back around. And, for a lot of schools, they've been investigating and adjudicating that conduct anyway. They just maybe use a different set of procedures. So they're not using their Title IX procedures, they're using some other procedures. And there might be a different level of process involved in those procedures. If that makes sense. So the proposed expanded scope of the new rules is here. So there's a lot that's the same, right? So quid pro quo is the same. The specific offenses covered are the same: sexual assault, domestic violence, dating violence, and stalking. But the hostile environment is different. Instead of the standard being severe, pervasive, and objectively offensive, it's only severe or pervasive, which is more aligned with employment law, and aligned with what folks understood to be the guidance about what constitutes a hostile environment prior to 2020. So I think for a lot of folks, it can be challenging with verbal harassment or even some physical harassment that doesn't constitute sexual assault. Hey, is it severe enough? It was severe, but it wasn't pervasive, right? Okay, then it's not going to meet that standard, right? And that was really challenging when folks were trying to figure out which lane do we put this in, which procedure do we use. But also, this is about more than sexual harassment, right? So these proposed rules are about more than the 2020 amendments were about. Like I said, those were really focused. The current regulations, as amended, were really focused on sexual harassment only. And these proposed rules also talk about discrimination on the basis of sex. So that's that box on the right side. They're being really crystal clear that discrimination on the basis of sex includes, sex stereotypes, pregnancy or related conditions, sexual orientation, and gender identity. And I think there was an argument before these proposed rules, if they ever become final, there was an argument that all of that was included anyway beforehand. But if that's not clear, they wanted to make it clear in regulation. There was some case law on the Title VII side. Title IX has historically followed Title VII as far as its interpretation of what is sex and what is sex discrimination. But belts and suspenders. You might as well say what you mean and mean what you say, and put that right into the regulation, which makes sense. So we talked about already, there's a bit of expanded responsibility, heightened standard of responsibility, more clarity about pregnancy and related conditions. Obviously, discrimination on the basis of pregnancy and related conditions is is prohibited. They define pregnancy and related conditions differently than they did last time around. They haven't amended that section of the regulations in dozens of years. So it makes sense that the language has changed, right? The language we use around the conditions related to pregnancy have changed. We're not using gendered language around pregnancy in 2023 that we might have used in the 80s or the 70s. So we see a little bit of change there, and a real explicit bar on peer retaliation, and knowing that not only is it prohibited for a school to retaliate against against a party or a participant in the process, but also the school has an obligation to prevent and respond promptly to peer retaliation. And I think most policies I've seen, and certainly all the ones I've written, say that. But it's just nice for it to be, again, in the regulation, a little bit of belts and suspenders. These proposed rules are seen as a bit of a win for the LGBTQIA plus community. We use LGBTQI plus in here because that's what those are the letters that were identified in the proposed regulations. There is a footnote from the Department of Education clarifying that they're trying to be as inclusive as possible, and they sort of list out all of the identities that they're trying to cover, with the understanding that language is always evolving. So I know sometimes people say, hey, how did you choose LGBTQI? Why didn't you say QIAA, or why didn't you stop after T, or something like that? And we really try to use the language of our regulators so that our language can mirror the regulatory requirements as much as possible. So that's just a little bit about the language. Again, there's a separate athletics rulemaking that received its own boatload of comments that the department will be sorting through as long as they are open, which might only be for a couple more days. There also is a new paragraph to address the intersection with disability law, which is important. And a lot of people are doing that already, saying, hey, if you are a participant in this process in some way, you're a party, you are a witness, and you need an accommodation, let us know. And there's this misconception on the student side that, hey, my school knows I get accommodations, so they'll know what I need. The Title IX coordinator will just know. They'll look up my name and it'll be, my name, my address, my phone number, and my accommodations. But that's not really the case. We know that because we know that that's not how records are kept. And we know that the records of the, accessibility office are totally separate from the records of the Title IX office or the registrar's office or the bursar's office, and never the twain shall meet, right? So you don't just look up a student and it just tells you their whole story. And that really wouldn't be appropriate under FERPA anyway, for it to be accessible, but definitely for it to then be accessed. Maybe someone could technically see it, but they're not looking, they're not reading it. It's not part of their job. They have no reason to know. You walk past that filing cabinet, it doesn't mean you're going to open it and read every folder. So, these are the things to think about. So we try to notify students, hey, if you need an accommodation in this process, let us know. And even sometimes going as far as to proactively tell them, you might think we already know what you need. We don't, right? Unless you tell us to go talk to the accessibility office, we're not going to proactively do that because, for your privacy. This is really, it's only, something you might need. Again, and someone's academic adjustment or meal plan adjustment based on their disability has nothing to do with their participation in the Title IX process. So just things to note. And on the K-12 side, it is required. On the college side, for the proposed rules, it's just, an idea hey, you might want to do this. You might want to coordinate a little bit better, which a lot of people are already doing. Response and notification, employees are required to notify the Title IX coordinator if they are not confidential. And luckily, it's a little bit more permissive here about who can be confidential than the Obama era guidance. The Obama era guidance was really limited about who could be a confidential resource. It didn't really give the discretion to institutions to designate who was. It was about their licensure. So I prefer that schools have the ability to designate. That way they can say, hey, we have these amazing counselors who are, they're peer counselors, but we want to designate them as confidential because we know they can be a great resource. They'd be permitted to do that now, where they under the proposed rules, if and when they become final, and they weren't able to do that back in 2014, 15, because the guidance said really people need to be unless you're a licensed counselor, you can't be confidential, or clergy, or some of these other pieces of health professionals, which was challenging because we had a lot of people who were not licensed counselors whose students felt comfortable going to, and they were in a role that felt like, oh, they're a crime victim advocate. We wanted them to be confidential. We wanted them to be a resource. So that was something challenging that we had to sort of work around. And I think we are ready for our first poll.
Yeah, we sure are. So we'll be launching a poll now. There'll be a graph icon at the bottom of your screen. And if you would be so kind to go in there and cast your vote, that would be fantastic.
And I'll tell you, I know that everyone was, thinking about, well, last February, 2023, people said, I know we have some updates you want to make to our policy, but we're just going to wait because we're going to have new regs in May. That was the story, right? But then May came and went, and now October is coming and going. And I just feel like it's tough to be living with a policy with gaps, or with stuff that's confusing, or that you just wish you could change. And if you were holding on it because your process to amend is cumbersome, now you're talking about this whole academic year for sure, maybe part of next, I don't know. So it's pretty tricky. But I know some people have at least started designating, like, hey, when the regs do come out, who's on the committee? What are we going to do? Are we using an outside help to write our policy? Are we going to do it internally? Who's going to be at that table? At least let's figure that out now, so that we're more ready, right? Like, you don't have to have a draft policy because we don't really know what the final rules are going to say. I mean, they could look exactly like the proposed, they could be different, but at least knowing who has to be involved, what's our timeline? Like, does it need board approval? All that stuff is at least a way to be ready without doing so much work.
Seeing some great results coming into the poll, and pretty split up. Looks like leading the way, we feel pretty comfortable with some of the tools and programs that are in place, but quite a few folks who maybe aren't in that same spot as well.
And I think that I wouldn't panic if you're, quote, not ready, because ready for what, right? Like, we don't really know what they're going to say. We also don't know if they're ever going to happen. Like, they probably will happen, but we don't really know, especially just because we're getting so close to the election that if they're delayed, and I'm sure there's things Congress can do to delay, and if they're delayed, and then we have a change, it just may be that they don't happen somehow, in some way. I don't know exactly what that looks like from an administrative procedure perspective, but it is certainly possible.